Good morning. The time is now 10 o'clock and the inquiry is open. Can everybody see and hear me?
Good morning, Madam. I certainly can.
Thank you. Mr. Boyle?
Madam, can you see me? I can't see myself.
I know I can't see you, but I can hear you.
Yeah, I've got that so far as well. What I can't find.
Bottom left-hand corner of your screen.
There we go. There we are.
There we go. Excellent. Thank you.
Thank you.
Okay. I'm just going to move these onto the side screen. If at any time anyone can't hear me, if you could just use the raised hand function and I'll try to rectify any issues that we do have. My name is Janet Wilson. I'm a Chartered Town Planner and I've been appointed by the Secretary of State to hold this inquiry. The inquiry is into an appeal made by Bargate Homes and Vivid Homes under Section 78 of the Town and Country Planning Act against the decision of Basingstoke and Dean Borough Council to refuse planning permission for outline planning application with all matters reserved, except for access, and that's for 75 dwellings, open space, allotments, landscaping, and access via Sheepfair Lane. And that's at land west of Pond Close, Overton, postcode RG25 3LY. Firstly, I shall deal with some housekeeping matters and then say a little about the organisation of the inquiry, including the procedure and timetabling. I'm just looking to see what participants I've got. Thank you. Before proceeding further, participants need to be aware that the event is being live streamed and recorded and will be accessible both during and following proceedings. These arrangements are being made by the council and not by the inspectorate. They will be keeping an attendance list of people registered into the hearing. I do have a colleague from the inspectorate observing proceedings today, though he will not be taking part in the inquiry. At this point, I just want to say a little bit about virtual proceedings. If there are any issues with connections to the event or you lose your connection, please retry the link that you've been given. And if you have any, if problems persist, can you contact the council's Democratic Services team using the details issued to you before the event. At the end of each session, please remain logged in with your cameras and microphones switched off. If you log off during the day, then you will be able to follow proceedings on the live stream, but you may not be able to be readmitted to the live session. At the end of each day, you should log out completely and use separate arrangements for subsequent days as they have been issued to you. Other than today, we will start at 9:30 each day, with the timetable being based on the submitted timings from the parties. I'm hopeful that we'll complete our work in that time, and I'm expecting advocates to stick to their promoted timings. Our virtual day is divided into sessions of ideally no more than 1.5 hours at a time, and that's principally to ensure that people don't get screen fatigue. Normally we'll have a mid-morning break, and the inquiry should finish for the day around 4:30, but it may be slightly later depending on the way proceedings are progressing. I will be aiming for a lunchtime adjournment at around 1 o'clock for an hour, but there is some small flexibility in these timings depending on whether that's a convenient time to break. At adjournments, I'll be the first one to leave the virtual room, and this is to avoid being left with one party or the other. Please can all other parties remain logged in, but your microphones muted and cameras switched off. Just to be aware that if you are having a conversation in the room and you are unmuted, then this will not be private. Everyone will be able to hear the conversation if they are still logged in, and it will be on the recording. This is similarly the case when you arrive and are checked into the inquiry each morning. At the end of the day, when I leave the inquiry, the council will end the event and the sessions will close. You'll have to register again the following morning, as I've said. Please register in good time to ensure that the council's Democratic Services team can register everyone in readiness for a prompt start. During the event, unless you are speaking, it's helpful you keep your microphone muted to minimise background noise, and with the exception of the two advocates, cameras should remain switched off. For those attendees registered to speak, you'll be invited at a specific point in the programme. Please be aware that you're normally going to get one opportunity to speak, so make sure you address the points you wish me to be aware of. Please do not interject during the evidence of other speakers. I must stress that the use of the chat function during the inquiry is not permitted. It will not be monitored during the sessions. If you have a particular issue, please raise it during your own evidence. If one should arise and you have already spoken, please use the raise hand function and I will come to you in due course. However, be mindful that you will generally only have one opportunity. Can everybody please make sure that your environment is quiet, you're free from distractions, that your mobile phones are on silent or switched off. Please be aware that I may be looking to my left or to my right during the inquiry. This is because I have inquiry documents open on separate screens. Please do not interpret my looking away to be any lack of concentration on the proceedings. I will be listening to you. Participants are expected to observe courtesy and respect for the formalities associated with this event. If I consider the behaviour of a party is not appropriate for some reason, then I will say so. I do have the ability to mute that person's contributions with the ultimate sanction of ejecting you from the event. I hope that won't be necessary, but it is an option that's open to me. I should explain, and particularly for attendees, that towards the end of the inquiry, we will discuss what conditions could be imposed in the event that I were to allow the appeal. May I stress that this does not indicate any prejudging of the case and is a normal part of inquiry proceedings. I have a schedule of conditions provided by the council and will discuss what level of agreement there is between the council and the appellant on the precise wordings, and will be taking into account the national guidance on the wording and content of conditions. All documents relating to the appeal are available on the council's website. There may be a necessity to screen share if plans need to be referred to. However, this should not be attempted unless a request has been agreed by me, and also due to the fact that permissions may need to be altered in the background to enable that to happen. Can the council confirm that the revised timetable and all documents have been uploaded to the council's website? Can I just check with Ms. Perec that that's the case?
Madam, I believe so, but I'm just going to check my phone to ensure that that is correct.
Okay, thank you. I would emphasise that the timings on the programme you can be subject to change depending on how the inquiry progresses, but I'm hopeful that we'll try and keep to that which we've set out. I've undertaken a familiarisation visit to the site and surroundings, and I'm generally aware of the setting of the site and the context of it in relation to the centre of Overton. I will make a site visit after the close of the inquiry, but we will come back to that later. Towards the end of the opening, I shall outline the main issues. My screen has just gone off, just bear with me 1 second. When I've concluded my opening remarks, I'll hear a short opening statement, first from the appellant and then from the council. The opening statements will highlight the parties' broad positions, which is particularly useful for interested parties to set the scene for the inquiry. After the openings, we'll hear representations from interested parties, first any in support of the scheme and then those in opposition. After that, we'll commence the presentation of evidence to the inquiry from the witnesses. I shall now take the names of those who will be speaking. For the appellant, I have Mr. Christopher Boyle of Queen's Counsel, instructed by Turleys, who will be calling Mrs. Aaron Wright, the planning witness, Mr. Stephen Brown, the housing land supply witness, and Mr. Andrew Cook for the planning witness. Mr. Boyle, is that still correct?
Mr. Cook is the landscape witness, but otherwise, yes, madam.
Sorry, landscape witness, my apologies. Let me just. And for the council, I have Mrs. Rishi Parekh of council instructed by Basingstoke and Dean Borough Council, who will be calling Mr. Ian Dudley, the landscape witness, and Mr. Matthew Miller, the planning witness. Is that correct?
Yes, madam, but it's Ms., not Mrs. for myself. And we also have Mr. Magnus Magnuson, who will be participating as a housing land supply witness in the roundtable session. And madam, while I'm speaking, I can just confirm that all the documents, including the revised timetable, have been uploaded.
Okay. Just one other point, just to make, that I will be making notes throughout the proceedings. So please don't take my head down as any disrespect, but I will try and minimise the amount of time that happens. Can I just double check that the order of witnesses as set out in the revised timetable doesn't present any problems for either party?
Adam, thank you. I think it was to accommodate us, for which we're grateful. Mr. Cook's availability, as you know, was restricted this week. Obviously, it's not ideal that Mrs. Wright goes before Mr. Cook, but I'm not sure we can do very much about that.
I think if you were to reverse that, it may well mean that proceedings at the tail end of the week may become more difficult, but is that something that you wish to explore?
Well, again, I don't ask for that, madam, for the very reason you've indicated. I think we'll just, unless my friend has a problem with the landscape witness following Miss Wright's evidence. Obviously, Miss Wright's evidence relies upon the evidence of the landscape witness, but I think we just have to live with that sequence.
So, if there are any particularly difficult points that we need to raise with Mrs. Wright after Mr. Cook's evidence, will she be available to do that?
Yes, she is. She's available throughout. Thank you.
Okay, thank you. And just to confirm that the appellants have seen all the proofs from the council and vice versa?
Yes, we have. Thank you.
Yes, thank you.
Whilst I have a lot of people who've made representations, I think the number of attendees today is, at the moment I've got Anne Phillips and Claire Brady, who I think is down on my schedule as Miss Swinton. So can I just clarify with both of you?
Yes, madam. Excuse me. Yes, madam. It's Anne Phillips here.
And
it's Claire Brady. Swinton's my maiden name.
Okay, can I just double check at this point how you wish me to address you in the decision, because obviously your name will appear there. So can I just double check which one you want me to use?
Yes, thank you. Mrs. Brady's fine. I believe that we're being held in a virtual waiting room.
Well, I think I've just promoted you to the main room, but I think the Democratic Services will just put you back as attendees until after the break, and we come to the public speaking.
Thank you.
Okay. Now I do have an indication that councillors Tilbury and Phillimore may be joining us today. Is that the case? Can Ms. Parekh?
Yes, madam, that was my understanding as well. But although I can't see them as participants at the moment.
Okay, I'll
sorry, madam, I've just checked my phone, and actually my officer has said that they haven't actually registered in the end. So that probably means they aren't coming along now.
Okay, thank you for that clarification. That's helpful. And Ms. Phillips is speaking on behalf of Overton Parish Council, I understand.
Yes, that's correct, madam.
Thank you. I have been notified that there are some time pressures for Mrs. Brady, so I'll take you first on the public speaking session, if I may, And that just gives you some reassurance. I think you've got to be somewhere else later in the day. I understand.
Thank you very much.
Okay, thank you. If you speak and give evidence or ask questions during the inquiry, your name will be listed in my decision letter. As I say, the council will maintain an attendance list. If any of the witnesses wish for their professional qualifications to be recorded in my decision notice, please can you just indicate at some point during the proceedings. It may it'll likely be tomorrow before we deal with the appellant's evidence, as the programme today will be focused on local residents and this afternoon the commencement of the council's evidence. The inquiry will adopt the normal working proceedings. Initially, the evidence in opposition will be presented with the witness giving evidence in chief, and then subject to cross-examination by the appellant's QC, Mr. Boyle, and Ms. Perec may then have some follow-up questions as re-examination. I may also have questions to ask if they've not already been covered in evidence. After I've heard the conclusion of all the evidence, there will be a discussion on conditions, and closing submissions will be most likely on Friday. It will assist me if these submissions be made available electronically prior to their delivery, and sufficient time will need to be given to enable that to happen, because they go to the inspectorate and then onto me. So if you could avoid sending them at the last minute, that would be helpful. Please would advocates reference closings ideally with footnotes highlighting where the references or evidence you refer to can be found. I don't have anybody else registered, so normally I would ask whether there's anyone from the press present in the session, so that I can add the names to the list, but I don't see any other attendees unless it's one of the panelists that I've not been made aware of. So no press present, no hands up. Okay, thank you. As I've already mentioned, the session's being live streamed and recorded. Does anybody else intend to film or record the event? No? Okay. I have copies of the council's letters of notification. These are dated the 18th of June and the 6th of September 2021, and these confirm the details of the appeal and the date and time and nature of the event, and a list of addresses to which those notifications were sent. Can the council confirm to me that all relevant parties have been notified and that the site notice has been posted?
Yes, madam, that is correct.
Thank you. And this is principally for the attendees. I do have copies of all the representations made to both the original planning application and to the appeal, and I've read through those, and I'll be taking these into account in reaching my decision. It's not necessary for representatives to go through their written comments, but mainly to highlight points that they particularly want to, so that I can be aware of them. I held a case management conference call on Friday the 6th of August, following which I issued a post-conference note. That session related to procedural matters and highlighted aspects of information on which I required clarification. The merits of the case were not discussed. Following this, the advocates indicated the witnesses to be called and the timings required, and I'm proceeding to a timetable framed up around those. Can I just confirm that all the participants have had sight of that timetable?
Yes, madam, thank you.
Okay, thank you. I shall follow the procedure in the 2000 inquiry procedural rules from the Town and Country Planning Appeals determination by inspectors procedures of 2000. For the benefit of those unfamiliar with the procedures, following my opening remarks, the process will be that we will outline the agenda with the council's witnesses, followed by those of the appellant. As I've already mentioned, evidence will be given as evidence in chief and then subject to cross-examination with questions following that. Opening statements will be first from the appellants to set the context, and then the council, and then public speaking session to follow that. And then after that, we'll proceed through the council's witnesses and then the appellant's witnesses. As Mr. Boyle's already said this morning, the appellant's landscape witness is not available till Thursday, so we'll hear the planning evidence first. Please do not view this as any measure of importance allocated to either of those particular subjects. It's just the way the timetable has worked in this particular instance. Matters relating to housing land supply and to the appellant's submitted unilateral undertaking will be dealt with by roundtable sessions, which will be a discussion led by me to answer the questions that I have. There will also be the discussion on conditions, as I've mentioned. These are all normal parts of inquiry proceedings, and we'll look in detail at those particular aspects. Closing submissions will take place on Friday, with the council giving their closing before the appellants. I've already talked about the breaks that we intend to have mid-morning and at lunch. And just to reiterate that during the formal sessions, I will take the main evidence as the written evidence as read, and then the advocates will highlight the particular issues for their witnesses. If advocates wish to refer to particular documents, if you could let me know at the beginning of that session, just so that I can marshal those documents and have them ready for when you wish to refer to them during your examination or cross-examination. In terms of plans, at this point, just to clarify the plans that were before the local planning authority when it made its decision, I have 3 plans listed. That's the location plan, and that's drawing reference 1164001 revision C. A parameters plan, drawing reference 1164008 revision A. And then proposed step from Dellans, drawing number ITB 15180 GA 005 revision C. Is that correct, Mr. Boyle? Those 3 plans.
Yes, thank you, Madam. I'm going to say yes until Miss Wright tells me otherwise.
Just one point on the 3rd plan, which is the proposed step from Dellans. I noticed that part of that is outside the red line area. So at some point in proceedings, I need to know how that's going to be handled, because I note whilst it's in a condition, we just need to look at the precision of that to ensure we can achieve what it is you're intending. So we'll come back to that later in proceedings. And the status of all other plans which have been submitted are taken to be illustrative or for information. That's the basis on which I'm proceeding. All documents and evidence should already have been provided, although I do have a request for the appellant to submit an additional document relating to site sections. So I just really need at this point to explore why that material is relevant, why it was not received in accordance with the timetable, whether the council's seen the evidence, and whether they object to its inclusion. So if I can come to you first, Mr. Boyle.
Thank you, Madam. Well, the first point easily explained, it's my fault because I asked the document to be produced, having seen and reviewed Mr. Dudley's evidence. You will have seen that in his evidence, he makes a point about buildings being visible from a certain piece of road. And when in discussion with my team, we established there was a gateway along that road, I asked that some indication be made as to the relationship between the proposed buildings and the existing vegetation that runs along the sunken lane between the two. And we didn't otherwise have a site section showing that, so I asked for that to be produced and circulated. The provisions that have led to it being produced are set out within the site section notes, so you can see the basis on which the drawing has been done. The point that we'd be making in any event is apparent, namely that you're not going to see anything material from that point of view.
Well, could I just,
forgive me?
Could I just stop you there a second, because I actually haven't seen this plan yet.
Oh, have you not?
What I want to do is to find out whether or not the council have seen it, and whether or not they are agreeable to it being used during the year, because it's late information. So I purposely haven't opened it because I want to know what the council have to say on it, as to whether or not we are going to accept it in evidence.
Thank you, Madam. Well, so in that case, that's the explanation, I'm afraid, for it arriving late, as it were. It's because I had asked for it, having reviewed the council's evidence, and then it took a while to be produced. It is a single sheet with 2 sections from one viewpoint mentioned in Mr. Dudley's evidence, and the notes on the document indicate how it's been constructed. It was circulated to the authority at the same time it went to PINS, we'll hear in due course if they have objection to it being submitted.
I think I was notified of it yesterday. Can I come to Ms. Peck then, just to see what the council's position is on that?
Yes, thank you, Madam. The council does take issue with this new site sections. In summary, really, our position is that it is, in effect, as Mr. Boyle has already pointed out, rebuttal evidence for which clear provision was made in the timetable, and that had a deadline of the 14th of September. And so there's no good reason why it took until yesterday afternoon for this to be produced and circulated. So we do not consider that it should be allowed at this late stage, because it would be prejudicial to the council's case. And there's been no proper opportunity for the council to properly deal with this new drawing.
Okay, I think probably the most sensible way to deal with that is to make sure that the positions that you are illustrating as those viewpoints are actually on the itinerary for the site visit later in the week. So the document that I want to inform the site visit will show me all places that I need to look at the site from. So I suggest, Mr. Boyle, if those 2 viewpoints, as you put them, are on the site visit itinerary, then I will look for myself when I do the site visit, and we'll be able to see from those points whether I can or can't see the existing development.
It's not the existing, Madam, it's the proposed, but yes, and it's 1 viewpoint, not 2. It's 2 sections, because there are
two angles. Okay.
two areas of development. It would help the appellants to understand whether the council disputes any of the facts set out in the section just simply being a graphic representation of the facts.
Well, you've heard what Ms. Peck has said about the lateness of that submission, and the fact that the council's witnesses have not had an opportunity, in fairness, to check any of that information. And Ms. Peck, did you want to?
Just by way of very initial comments, having set out that we haven't had a proper chance to inspect those things, just in terms of initial comments, one thing that that certainly was brought to our attention was the fact that the proposed dwellings were proposed to be 10 meters high. That's not something I think that we had picked up previously in any of the written evidence, but that might be an oversight. I'll look to Mr. Boyle to confirm whether that's a new point, or whether that has been raised previously. But in terms of the other main comment on the modelling, what we would say is that it's just crude modelling. It's not determinative, because obviously it assumes that the existing vegetation and the trees are solid structures, and it can't possibly account for winter views. So to be frank, Madam, you'll have the best opportunity to gauge for yourself at the site visit.
Okay, thank you. At this stage, I'm not minded to admit that that information for the reasons just discussed. So I think if you are going to pursue any of those points, you'll need to do those verbally via your witnesses, Mr. Boyle.
I'm quite content with that, Madam. It was an attempt to be helpful for you, nothing more than that.
I appreciate that point, but obviously I need to be fair to the council in these proceedings in the same manner.
Yeah.
Okay. Right, from where are we now? In terms of the main issues, I previously set out what I considered to be the likely main issues in my pre-conference note. That was whether the appeal site was in a suitable location for housing in the context of the development plan and national policy, and whether the effect of the development on the character and appearance of the surrounding area with reference to landscape character, scenic character and visual quality. Are the main parties in agreement over those points, or is there anything else to add at this juncture?
Nothing from us, Madam. Thank you.
No, Madam, thank you.
Thank you. Are there any questions from any other participants before I proceed? Just check the attendees. Okay, thank you. In that case, can I invite the opening statement from the appellant, please? Can I just point out that I don't have a soft copy of your opening statement. Mr. Boyle, did you send one?
Madam, yes, you should have had one from PIN's secretariat sent this morning.
Just bear with me 1 second. It may well have come through whilst we've been talking.
So what I asked, Madam, was that it go through to you, but be embargoed for wider circulation until now. Obviously, it now can be circulated wider.
Well, I don't have it on my system. If you want me to just briefly pause and ask that question, I can do. Otherwise, I'll proceed on the basis of I'll make notes as you proceed.
It may be no, well. It would be much better, I'm sure, Madam, if you had the text. It's not terribly long. I just wonder, because we don't, of course, have this being a Zoom run by the authority. We don't have a PIN's contact on the call.
Well, it would be if you send it through to Liz Humphrey. I will just send her a quick message now. You bear with me 1 second. I'll just check whether it's come through to her.
Okay, well, Miss Wright is on the call. If I ask Miss Wright to send it through to Miss Humphrey and copy Land Friend and Democratic Services, perhaps, and then it'll be able to be circulated.
Okay, I'll just go and do that, and I'll be with you in 2 minutes.
Okay.
Hello, Mr. Boyle.
Madam.
Yeah, no, I don't have a copy with me. It hasn't come through to my email. So in the interest of not holding up proceedings, if you proceed, I'll just make some notes as you go through.
Okay. Well, Madam, I've had it confirmed. It's been sent again this morning, so it will come to you shortly, I'm sure. But in the meantime, yes, certainly, I can proceed with the written statement. Forgive me, I'm just checking. Yeah. Thank you. So, Madam, these are the opening submissions on behalf of the appellants. That is Bargate Homes and Vivid Homes, in respect of an appeal against a refusal of outline planning permission for 75 dwellings, including 40% affordable housing, open space, allotments and landscaping, that's the scheme, on land west of Pond Close, Overton, that's the site. The site lies outside but immediately adjacent to the out-of-date settlement boundary of Overton, in a location acknowledged to be sustainable for the purposes of residential development, with access to the requisite services and facilities by non-car modes. The scheme is accessed off Sheepfair Lane through the recently completed Bargate site adjacent, on a site identified by the Neighbourhood Planning Forum, that is the Parish Council, as appropriate for promotion as a neighbourhood plan allocation, and is promoted in the context that the Council acknowledges that it cannot demonstrate the required 5-year housing and land supply. The application was recommended for approval by officers, but refused planning permission by members at committee. Reason for refusal 2 concerned matters which were recognised to be able to be overcome by a suitable Section 106 obligation and or conditions. The terms of the draft of the Section 106 obligation and of the conditions have now been agreed. It's common ground that reason for refusal 2 has been overcome, and it is no longer pursued by way of objection by the local planning authority. Reason for refusal 1 remains, therefore, the only operative objection to the grant of planning permission for these much needed houses. It alleges a landscape and visual objection. Importantly, it does not seek to resist the scheme on the basis of the principle of being outside the settlement boundary and in the designated countryside. Madam, just pausing there, of your 2 main issues, therefore, it is the second that reason for refusal 2 concerns. The authority does not allege that the scheme should be refused by virtue of its location outside the settlement boundaries adopted in the local plan. This is an unsurprising, which suggests the welcome concession on behalf of the local planning authority. First, the settlement boundaries are in and of themselves out of date, being predicated on non-NPPF assessments of development needs, now outdated. Secondly, the Council's inability to be able to demonstrate the required 5-year housing land supply is agreed to engage paragraph 11D of the NPPF, such that the most important policies are deemed out of date and reduced weight may be accorded to them. These include the strategic policies SS1, SS4, SS5, I think that should then say SS6, none of which, very properly, is cited in the reason for refusal. Thus, there is no in principle objection to this site. Although there's disagreement as to the precise extent of the Council's failure in relation to housing land supply, that is 4.83 years against 4.2 years for the appellants, there is agreement that the consequence of the failure is that only moderate negative weight may be given to the spatial policies breached, while significant positive weight must be given to the delivery of housing and of affordable housing through the scheme. In this regard, it's noteworthy the appellants are jointly Vivid and Bargate Homes, a company owned by Vivid. As one of the largest affordable housing providers in the south of England, Vivid has no need of bank funding and will be able to proceed to build out as soon as conditions are discharged. Not only would Vivid deliver the acutely needed 40% affordable housing, but Bargate's commercial profits are reinvested by Vivid in their wider affordable housing programme. Thirdly, the site is acknowledged to be an accessible location for access to services and facilities, well connected to the settlement of Overton, which itself is identified as a sustainable settlement for additional housing growth, and adjacent to the recent greenfield extension to that settlement, also by Bargate Vivid, which sets the tone for the scheme now at appeal. Fourthly, the planning history of the site reveals that while it is currently unallocated, this should not be seen to be adverse to its credentials as a suitable site for allocation. The parish council identified it as a site suitable to be allocated through the neighbourhood plan process and included it within the draft neighbourhood plan that went to examination. This necessarily included its performance in terms of landscape and visual impact. Its eventual deletion by the examiner was not as a result of finding against it on its planning merits as a suitable location for housing. Fifthly, the scheme now at appeal was carefully formulated with planning officers of the local planning authority, notwithstanding the non-allocation in the neighbourhood plan. The configuration of development parcels and the devotion of a significant part of the site to open space and green infrastructure takes advantage of the topography of the site and its relationship to the existing urban area to create a scheme which fits with the grain of the locale while limiting wider impact on the receiving landscape, a landscape which is acknowledged not to be a valued landscape for the purposes of paragraph 174A of the NPPF. This, we suggest, sets an important context for the remaining operative reason for refusal. Its terms and justification will now be explored in evidence. However, it's worth noting that in the context above, and in the acknowledged absence of a demonstrable 5-year housing land supply, the harm to this non-valued landscape would need to be significantly and demonstrably more weighty than the sum of the significant planning benefits, which it is common ground arise from the provision of housing and affordable housing, the economic contributions, the ecological and the landscape improvements that form part of the entire scheme. By contrast to the council's witness, Mr. Dudley, the appellant's landscape architect has considered the entirety of the appeal scheme. Even Mr. Dudley recognises that the built form proposed will be in character with the adjacent settlement. Development in character with its receiving landscape is not in and of itself harmful, even if it is different inevitably from the current land use. But Mr. Cook additionally takes into account the improvements to the extensive part of the site not proposed for housing development. This is a scheme which, far from causing harm to the landscape and visual resource of the borough, will bring tangible landscape and visual benefits. Taken either way, that is, limited and localised harm to a non-paragraph 174A landscape, or actually an overall benefit, the manifest planning merits of the scheme, we say, favour its approval in the public interest, both on a straight balance, but even more emphatically on the tilted balance in paragraph 11d(2), which is acknowledged to be the policy test by which this appeal falls to be judged. Accordingly, Madam, once the evidence has been explored through the inquiry, the appellants will be respectfully inviting you to allow the appeal, follow the Parish Council and the borough's professional officers in supporting the approval of this much needed housing and its associated landscape and ecological improvements. Thank you.
Madam, you're muted, but
my apologies. I've got a bit background noise going on the school playing field outside. I'm trying to minimise any interruption.
Thank you, Madam. Are you content for me to present?
I am content, sorry.
Thank you. And Madam, sorry, can I check that you have this in soft copy? Yes, and I'll make sure that Mr. Boyle's team is emailed a copy as well if that hasn't been done already. Madam, by way of introduction, this is an appeal relating to an application for outline planning permission with all matters reserved except for access for 75 dwellings, open space, allotments, landscaping and access via Sheep Fair Lane. The application was refused by Basingstoke and Dean Borough Council's Development Control Committee for 2 reasons. As Mr. Boyle has indicated, the second reason for refusal is no longer an issue between the parties, those matters having been addressed through a signed Section 106 agreement. The first reason for refusal, which remains an issue, is set out as follows. By virtue of its location and size, the proposed development would result in the loss of an area of undeveloped countryside that would significantly impact on the setting of the village of Overton, adversely impacting on the local landscape character and scenic quality. The proposed development would not successfully integrate with surrounding development, resulting in significant and adverse impacts on the visual quality of the area. It is not considered that this harm could be adequately mitigated against. The proposal is therefore contrary to Section 15 of the NPPF, and that was the 2019 reference, and policies EM1 and EM10 of the Basingstoke and Deane local plan. The harm identified would significantly and demonstrably outweigh the benefits of the scheme, contrary to paragraph 11D small 2 of the NPPF Feb 2019. As noted in the Council's statement of case, this reason for refusal should also have referred to the Overton Neighbourhood Development Plan policies H1, H3 and LBE1. The Council's case is summarised below. First, looking at impact on local landscape character, scenic quality and visual quality. For the avoidance of doubt, the Council notes that it does not take an in-principle objection to this site being outside the settlement policy boundaries. Rather, its reason for refusal relates specifically to the in-principle landscape and visual harms arising in respect of this development by virtue of its location and size. While it is acknowledged that the Council's officer report recommended approval, it is noted that its landscape officer did object to the application on the basis of adverse impacts on both landscape character and visual impact. These significant adverse impacts are set out in detail in the Council's landscape and visual evidence. In summary, the proposed development represents a large and incongruous extension beyond a long established and logical boundary to the village of Overton and will adversely impact on its setting, the local landscape character and the scenic quality. The complete and permanent loss of the current open and arable fields will have an adverse impact both in terms of the overall character of the site as well as its setting. The development will have particularly adverse impacts on the network of historic sunken green lanes that run alongside the western and northern boundaries of the site. At present, the site is an important buffer between the village settlement and the sunken lanes. The scheme, if consented, will fundamentally and permanently alter the setting of these historic routes by bringing urban features and built development close to their edge. The proposed development will also result in significant adverse visual effects upon a number of sensitive receptors, both in the immediate vicinity of the site and in the wider countryside. The development would therefore fail to satisfy local plan policies EM1 and EM10, Overton Neighbourhood Development Plan policies H3 and LBE1, and paragraph 174 of the NPPF. Turning then to the planning balance, it is common ground that section 38(6) of the Planning and Compulsory Purchase Act 2004 sets out a plan-led approach to development, requiring proposals to accord with the adopted development plan unless material considerations indicate otherwise. It is also common ground between the parties that the Council is not able to demonstrate a 5-year supply of deliverable housing, although the parties disagree as to the extent of the shortfall, and the reference there is to the Statement of Common Ground on Housing Land Supply, which is core document 4.4. Accordingly, it is common ground that paragraph 11D of the NPPF, that is the tilted balance, is engaged. As to the planning balance, the parties further agree that 1, significant weight should be given to the delivery of housing. 2, local plan policies SS1, SS4, SS5 and SS6 continue to attract moderate weight. And 3, local plan policies EM1 and EM10 attract full weight. The Council also gives full weight to Overton NDP Neighbourhood Development Plan policies H1, H3 and LBE1. As to the other proposed benefits of the scheme, the Council considers that they attract limited weight insofar as they are mitigation measures required for the development to minimise additional harm. Taking into account all of the above, and for the reasons explored more in its evidence, the Council submits that the adverse impacts of the scheme on local landscape character, scenic quality and visual quality significantly and demonstrably outweigh its benefits, and the Council therefore respectfully will invite you to dismiss this appeal. Madam, you're still on mute.
Thank you. I will try harder with that mute button, unmute button. Okay, I'm just looking really now. We finished the statements slightly earlier than anticipated. But is it sensible before we start the public speaking session just to take a short break, probably till 11:15, and then we'll come back to commence with the parish council and the other speaker. Content with that timing? Okay.
Yes,
We'll resume again at 11:15. Thank you.